Again, my name is James Pirini. I'm a volunteer with the TEK Summit. I have the honor and privilege here to introduce Mark Black. Mark will be talking for 45 minutes or so about the legal implications of TEK, followed like in previous sessions with a Q&A at the end. If questions come up as we're talking, feel free to leave those in the Q&A box. Otherwise, and again, there will be an opportunity at the end to ask Mark your questions. So it looks like we're at about time. So Mark, if you're ready to go, we can get started. Thank you everyone for being here. Mark Black.
Hello everyone. So today we'll be talking about the legal implications of TEK. Hopefully after 3 days of conference and different meetings and whatnot, you have a somewhat working definition of what traditional ecological knowledge is. Since law is such a web of avenues, today we'll be specifically focusing on intellectual property law. Something I'm really fascinated by in the scope of pertaining to indigenous people. Indigenous interest in intellectual property law can affect around 370 million indigenous people located in over 70 countries. So I'm putting this disclaimer out there. There is a picture of two Aboriginal men, and I am not sure if any of them are still alive or deceased. So if you are from these heritage, I couldn't be 100% sure these individuals were alive when I took this image from the web. So proceed with caution if you wish to continue. So what are we going to talk about today? So we're just going to run down the schedule real quick, give you some working definitions on some vernacular I'm going to use today, a brief history of IP law in terms of how it has been developed in the United States context, components of IP law, because I'm not sure the different grasp of people's expertise of this, and then some current challenges, some current problems to think about that involve intellectual property law in terms of indigenous people, and then some existing frameworks that could bolster indigenous rights, tech, and intellectual property rights altogether, and then opportunities to learn more about IP law and how it pertains to indigenous peoples around the world. So I'm taking a more of an international approach than a domestic approach, because this is not only impacts North, but people everywhere around the world. So let's go some definitions. You all have a working definition of TEK, TK, traditional ecological knowledge. It's also called science, communal knowledge, and that basically refers to the evolving knowledge acquired by indigenous and local peoples over hundreds or thousands of years through direct contact with the environment. Then we have one of our main intellectual property. It's basically creation, inventions, literary and art designs and symbols, names, and images used in commerce. Then we have a more niche portion of intellectual property, which is indigenous intellectual property, or I call it IIP, IP for short. This is intellectual property that is collectively owned. So not one person owns it or one company owns it, and it's owned by voracious indigenous peoples, and by extension, their legal right such property. This property can include cultural knowledge of their groups and many aspects of their cultural heritage and knowledge, including that is held in oral history, because a lot of cultures do not have a written form of language. And depending on what tribe you are, you do have some form of recorded history, but it's just, not written per se in terms of a Eurocentric outlook. And lastly, biopiracy. Disclaimer, I'm not really going to Monsanto. It's low-hanging fruit for me, so I'm going to give you another example later on about biopiracy, which is pretty interesting. This is when researchers or research organizations take biological resources without official sanction, largely from less affluent countries or marginalized people. These can be a wide range of things. Usually it stems from the field of genetic engineering, and it's pretty rampant still today. So to understand a little bit about IP law, we have to sort of delve into the roots of intellectual property, where it began and how it sort of developed in the United States. So intellectual property law dates back at least as far as Europe. In those times, guilds or associations of artisans in a particular industry were granted authority by the governments to control the regulation and conduct of their respective industries. Exercised a vast amount of control over what items could be imported, marketed, and produced, and the manner in which new inventions, devices, and procedures could be introduced to the stream of commerce. Because of the authorities for these guilds were given by the government, and because the concentration of power to regulate such industries were from a select few, it did far more to stifle creativity and invention than to encourage it. Cutting to the framers, when the colonies secured independence from England, each colony except Delaware passed its own copyright law. Further, prior to enacting the United States Constitution, each of the 13 original colonies had its own distinct body of patent law. And then we'll go into what patents mean and so on and so forth. This, of course, led to a severe degradation in the value of copyrights and patents. So thinking about it this way, what good would a New Jersey patent be, for example, if it was unenforceable in neighboring New York? In order to rectify this matter and reward innovation and to greatly facilitate commerce among the states, the drafters of the Constitution felt that intellectual property law should be within the province of the federal government and not the states' governments. Therefore, the framers of the Constitution drafted this power. It's found in Article 1, Section 8. Basically, it states to promote the progress of science and useful arts by securing limited times to authors and inventors exclusive right to their respective writings and discoveries. I want us to think about this in context, because in the context of the United States, when this is being written down and ratified and whatnot, indigenous people were not at the decision-making table. And another group of displaced indigenous people, African Americans, were enslaved at the time and not at the decision-making table as well. So because of that lack of recognition, this causes all sorts of problems nowadays in terms of establishing dignity and respect with regard to traditional ecological knowledge. So there's intellectual property, and there are the three main components that make up the bulk of that field of law, and they are patents, copyrights, and trademarks. You might be aware of what some of these things are, but we'll just go over them. A copyright is to describe the rights that creators have over their literary and artistic works. Works covered by a copyright range from books, music, paintings, sculpture, and films, to computer programs, databases, advertisements, maps, and technical drawings. Trademark, hence the Nike swoosh, is an example of this. Excuse me. A trademark is a symbol. It could be a word or words that is legally registered or established by use as representing a company or product. And then a patent is a license conferring a right or a title for a set period. I think in the United States, it's about 70 years. And it especially pertains to the sole right to years from making, using, or selling. And one thing to know about intellectual property that is different from indigenous property is the current state RIP laws reflect individualism and commodification by confining knowledge entitlement to private property and allowing solely owned exclusivity thereof. Indigenous conceptions of knowledge entitlement, generally communal, collective, and non-commercial in nature. In recent years, there has been an increasing number of indigenous peoples and or communities applying to protect their individual collective intellectual works, such as registering copyright for their paintings and sculptures, or making IP infringement claims against unauthorized of the traditional music or sign. So what does it look like when TEK and are undermined? It sort of looks like this. Obviously, as climate change the world seems to be slowly recognizing TEK, but not fast enough in many cases. We might be at I told you so for the world. It just seems things are getting more chaotic environmentally. These two pictures, on the left hand side, there is a kangaroo jumping through smoldering a smoldering hellscape. That's the only way I can describe it. This was from 2019, and this was the fire that engulfed the east coast of Australia. On the right hand side, this is more of a recent image. This is actually from the United States. This is from 2021, the Creek Fire in Madera County, California, which occurred in September. So just take a look at this, and these are the consequences when indigenous people are consistently having to fight to maintain a sense of control of their environment, and it backfires. So it's a little disturbing, to be honest. The problem with indigenous methodologies, such as in this case, what we're going to be talking about real soon, fire management or control burns, is that the knowledge is out there for anyone to take. And this next slide will be evident of that. So these two images are from two separate companies that are based in Wisconsin that specialize in land management, and one of the specialties is prescribed burns. From what I've gathered on the website, there was little to none of any recognition for where these methodologies come from. Native peoples from around the globe is fire as a tool of environmental management, and to see a group of people who are actively profiteering on these methods and not even acknowledging the original teachers, the original masters of these ways of testing. It's an injustice in its own, and this is one of the problems about indigenous intellectual property, is that it's not codified, at least currently, in our country, the United States. But there are frameworks that exist that we can take steps towards, but it rests upon desire as a collective, non-indigenous and indigenous communities as well. So I just showed you a group of people that actively get paid to do traditional caretaking, to engage in tech, but these are the actual people who should be getting paid in this line of work. On the left-hand side, and forgive me if I mispronounce your tribe's name, they are Ngaju people, and they're re-engaging in management of some woodlands in Western Australia. And this was like one of the first fire training days they've had in almost 30 years near Bolinia Rocks. Right hand side, this is a group from Northern California comprised of Karuk and Yurok peoples engaging in prescribing. In my opinion, indigenous people should be the first one paid, and we'll get into some particular theories on and methodologies on how we can still pay Native people who have developed these methodologies, but they might not have the capacity to take on everything, because there's simply too much work to be done, and we're already small enough that we need help, but in a way where it shows dignity on our end, and maintains a semblance of autonomy when it comes to engaging, when it comes to non-indigenous partners engaging in tech. I went to REI the other day and to pick up a sleeping bag, and I noticed some kayaks. And one of the things that is remarkable about indigenous people is, contrary to popular belief, indigenous people did invent things, from oral contraceptives, kayaks, hammocks, so on and so forth. One can argue democracy with the Haudenosaunee, but there are so many things that aren't taught in school, that Native people just roamed about the earth and didn't really have much control over their own environment or destiny. That isn't the actual case. Native people did invent things, and one of them is the kayak, at least here in the United States. The kayak was developed about 4,000 years ago by Inuit, Yupik, and Aleut peoples. And it got me thinking. There are a whole outdoor markets that sell kayaks, that there are whole industries that provide tours and rentals. And so I'm wondering, if people from that area kept a bottleneck of how their crafts were produced, how would their destiny look like? And I played with some numbers. So as of 2020, there's about 18.12 million kayakers in America, people who kayaked. And we'll be a little bit conservative here. So let's just say half of that actually own a kayak. But like the average price of a lower tier kayak, which is about $500, and say all those were bought at the same price, you're looking at about $4.8 billion. And I'm wondering, if a portion of that went to these communities, how different would it be? How much more influence they could have in their respective areas, in terms of engaging with the non-native community. When you add that much capital in a community, power dynamics change a little. So it always made me question, like, these companies that sell hammocks, what if people from South and Central America get a cut, what if people in the Caribbean get a cut of that? And as we'll discuss later on, there is a framework for that, which is pretty exciting. At first, I thought this was just nothing more than a beautiful flower, and it's much more than that. It's a product of biopiracy. Like I said, I wasn't going to bring up Monsanto, so we'll talk about this case. In 2016, this was a biopiracy case that surfaced between the French Institute for Development Research and local officials in French Guiana, which is an overseas department and former colony of France. This dispute exemplifies several common misunderstandings in biopiracy. At issue here is a compound name, SKE. I'm not going to try to butcher it right now, which was isolated by the IRD researchers from the Quassia amata plant, which is a small red flower tree native to Central and South America. These scientists focused on the species after they had interviewed members of the Galena, Pelican, and various Creole communities in the area about traditional remedies against malaria. A paper was eventually in 2009, and they confirmed that this compound had anti-malaria activity in test tubes and in animal studies. When they produced this paper, any Guyana communities, they also applied for a patent from the European, which was granted in March 2015. Research compound, they found it not through traditional preparations, from what they've observed through interviews, which was the form of a tea, but they found it through an alcohol-based extraction method. Thus, in scientific tradition, the compound did not come from traditional. It was discovered by the scientists in an alternate way. Nonetheless, it was the local Guyans and their plant knowledge that scientists to examine Q. amata and not thousands of other plants. And according to newly implemented laws and agreements, should have been made. Research even began. Now, French Guiana and the IRD are entering into discussions to form a agreement to settle this dispute. It again just goes to show that science continuously overlooks the impacts and other forms of scientific observation that indigenous communities provide. And that could stem from a whole heap of attitudes, from racism to just arrogancy. So this is just an example of that. Like I said before, there are existing frameworks to a more just system when when it comes to engaging in indigenous knowledge, intellectual property. One example of this is Law 27-811. This was written in Peru, particularly Article 8 of this law is pretty interesting, and it ties back to that notion of what if bulls who invented the kayaks get a cut from the kayak industry who use traditional ecological knowledge in a way where it be applied for their own benefit, for their own business purposes. In this law, Article 8 establishes a requirement of an less than 10% of the value before tax of gross sales resulting from marketing of goods developed on the basis of collective knowledge. And these funds then go to the development of indigenous peoples. I don't know how, if so it's best to, when you do read certain policies that involve indigenous people and their intellectual property rights, take things with a grain of salt, because these laws are still controlled by non-indigenous folks. So there is already still a power imbalance. Another framework that unfortunately did not pass in 2019 was Bill C-262. It was basically an act to ensure that the laws of Canada are in harmony with the United Nations Declaration on the Rights of Indigenous Peoples. It made through a third hearing session, but again, it didn't pass. The United States is no better. We voted against UNDRIP, or again, the United Nations Declarations of Rights of Indigenous Peoples. That was actually adopted by the UN on September 2007. 144 states. There are actually 4 votes against it, which was Australia, Canada, New Zealand, and the United States. Australia, Canada, and New Zealand eventually had a change of heart and voted in favor, but the United States ultimately did it. If you do get a chance to read the declaration, you want to focus on Article 11, 24, and 31. These articles particularly lay out the groundwork on how intellectual property should be protected in indigenous communities. However, problem with this is, and we'll put it in a United States context so people can understand. There's a lot of tribes in the US, right? One of the reasons we didn't adopt or ratify UNDRIP is Article 19. And I didn't put it on here because it has to do with consent. So anytime a government, and it's very vague in the wording because it doesn't, in our case, it doesn't say federal or state government, makes a legislative decision or an administrative decision that impacts indigenous communities, it must first get the consent of those communities. And what would that even look like in this country? Would it be consensus? Would members of council all get a vote? Would chairmans only get one vote? So that's something to think about if this is ever fully adopted. Unfortunately, hate to be the bearer of bad news, but there's a lot of good things in there, and it hurt a lot of pockets. Let's just put it that way. And because it will hurt a lot of pockets, the United States will not fully ratify it through the Senate. So it sits as a resolution. So basically meaning this is a really good document, but we don't like certain parts of it. So it's just going to sit there. It is unfortunate because, again, Articles 11, 24, and 31 really do a fair job at laying out the groundworks of IP. And then if you want to learn more about IP and how it's involved in traditional ecological knowledge, I recommend you look up these individuals. Ian Vincent McGonigal, he has written a paper about ethnopharmacology and how it relates to indigenous intellectual property. It's really fascinating. It also touches on, principles of biopiracy. Dr. Jane Anderson runs an organization called Local Context. They basically advise indigenous communities domestically and globally on how to protect their knowledge, catalog it, maintain it, etc., etc. Then we have Rebecca Sosi. She teaches at University of Arizona School of Law, and she's talked extensively about IP, and some of her writings are really fascinating. She's done stuff with the World Intellectual Property Organization, and they have produced articles that talk about TEK, what it means in terms of what it means through the lens of intellectual property law. And then lastly, Anyina Nwalchi, he's a professor at Nelson Mandela School of Law, University of Fort Hare. He wrote a paper that was published by the Marquette School of Law, and is basically documenting the rise of communal knowledge protections. And then on the right side, there's some, again, organizations to follow that do really good work in terms of TEK and engaging in different aspects of intellectual property, such as like data sovereignty and whatnot. And that is it. Thank you for listening. I hope you learned a little bit about intellectual property and how it relates to indigenous communities, and you've been educated on some of the challenges that some communities face, some examples of theft, outright theft, that non-indigenous communities engage in, and what the denial and the disregard of TEK and indigenous intellectual property actually looks like, and the effects it has not only for us, but for everyone else.
Mark, thank you. And James, I know you're going to moderate the panel, but I did just want to say that your last slide had something about indigenous sentinel networks. And I'm going to put a link in the chat to a recent publication from one of our keynote speakers, Dr. Jessica Hernandez, that was just published in an open access journal. It's a real short read. It's called Recentering Indigenous Knowledge in Climate Change Discourse, and it talks about these networks as well. So just to segue into this, and James, if you want to moderate the discussion, feel free to.
Yeah, thank you. And Mark, thank you so much for that. For anyone attending, if you had questions for Mark, please leave those in the Q&A box. If you're ready to go, Mark, we have a couple questions queued up.
Yeah, I just want to give a disclaimer. Even though I am barred in a tribal court, I'm not here to give legal advice. Thank you.
Great. So this first question, there's a little bit of a lead up. I'm going to just read it as it's written here. So this individual asks or says, it seems to me that there are two aspects to TEK, a basic philosophical framework involving the proper way to live with other species, beings, and landforms. Otherwise, all things are connected, and the discussions of the three R's. The second is the specific knowledge concerning the distribution and uses of more than human entities, like medicinal plants. In my impression, the idea of intellectual property focuses mostly on the latter, which I think is where we should focus the legal issues. Do you agree with this? So do you agree with specific knowledge concerning the distribution and uses of more than human entities should be the focus of law?
More than human entities. Can you repeat the question again? I'm sorry. Thank you.
Yeah, of course. So do you agree with the statement that the intellectual property should focus on specific knowledge concerning the distribution and uses of more than human entities like medicinal plants?
That's a good question, but yes, it should be expanded on non-human entities. It's a tricky balance too, because there are movements in the world that are advocating for legal rights on places, locations such as rivers, mountains, etc. And I don't know what the implications are if bodies of rights are given to places. How does that impact how indigenous people engage with that place? But yeah, just to answer your question, yes, hopefully. Is that question written down?
Yeah, and I can send that to you. We can send that to you afterwards.
Yeah.
So I can move on if you're ready. This one, another individual asks, are there any specific laws in place in the United States that protect the intellectual property of indigenous peoples?
Oh, there is a Indian Arts and Crafts Act, but it has to do with more along the lines of marketing. I believe that was passed in, I'm gonna fill my own test, 1995, I believe. And basically it says if you're selling a product and you're not enrolled in a tribe, but you're marketing as if you are enrolled in that tribe, that's a big no-no. That's a violation of that law. But the problem with that is people get around that stuff all the time. And that's where you get cultural appropriation, like from Nordstrom and other companies of the sort. I've seen the problem is, right, our laws aren't set up to protect specific, for example, basketry designs. Because if someone took out a trademark on a basket pattern, that means everyone else can't do that certain pattern, and that leads to a whole bunch of other consequences within the community. And then because of that, you see people like, because we're on the West Coast, Dutch Bros sell t-shirts with Northern California basketry patterns. And yeah, it's complicated to say the least. And there isn't a clear way out, right? Because there's so many communities here. Any piece of legislation that pulls through or judicial decision affects pretty much all of us. So yeah, hopefully that answers your question.
Yeah, no, that's very interesting. Thank you for that. So another question coming in, is there a group at NCAI addressing this issue, such as the NCAI Policy Research Center?
I'm not explicitly aware of that. Most likely there are. I don't know how aggressive the traction there is behind these sets of initiatives. There are a lot of things going on in Indian country. Seems like there's a lot of fires that need to be put out, and this is one of those fires. If you look up indigenous intellectual property on NARF's website, you'll find more activity, more articles, and yeah.
Thank you for that. I think Laura's going to jump on for the next one.
Yeah, I have a question, and I can't put my questions in the chat because I'm a host. So I heard what you had to say about UNDRIP and the unlikelihood of the United States actually ratifying UNDRIP. And UNDRIP is something that I reference all over the place in my research and my studies. Yeah. So I have a question for you about this. What do we need to do, or what would you recommend to listeners today to as like a course of action to encourage their representatives in Congress to create our own version of UNDRIP, specifically for the United States?
I don't think we can rely currently on state legislators to do anything impactful right now. But I will give you this. If you happen to be part of a nonprofit, I would highly suggest that, and especially if you are in the environmental movement sector, or you have anything to do with wildlife or land use or any of that, you look at UNDRIP and you actually adopt some of the articles within your organization in terms of how you interact with the indigenous communities. Unfortunately, I wish I could give a more positive outlook on how Washington will go from here, but you know, the last time the United States, I would say, like acknowledged UNDRIP was in 2010, And again, it was just, yeah, this is a resolution. It's really nice, but we won't adopt it, because there's stuff in there that will mess a lot of things up for people in power.
Thank you for that, Mark. We maybe have time for one or two more if people want to add any to the chat. I actually also have a question, if you don't mind, Mark. So something that I'm a fire person myself. I study fire ecology, and something that I've heard Bill Tripp from the Karuk tribe mention repeatedly in public forums is a history of their community practicing fire and having law entities come and disturb some of those traditional practices. I also see sort of expressions of traditional ecological knowledge that are sort of viewed as activism, like at Line 3 and Standing Rock, et cetera. Do you have hope for the future of protections for Indigenous people who are making of expressions of traditional ecological knowledge in public forums in ways that could be perceived as activism or against Western law?
Man, you just want me to make me into a pessimist. We live under a machine. We live under a machine that controls a lot of things, the government, the media. People don't even know about Indigenous people. A lot of these concepts that I just explained in my talk, this is the first time a lot of people probably heard of this. Both Indigenous and non-Indigenous alike. This is done on purpose. What activism does is, it challenges. We don't want to back down from things. We definitely want to challenge things, but there has to be a two-prong methodology. Boots on the ground and shoes in the courthouse. It can't. We can't all get arrested. You know what I'm saying? Like we need attorneys, but we also need people out there putting their bodies on the line. And unfortunately, that's how Indigenous activism works. And to recognize our brothers and sisters down in South America, activism is, it's rough down there. People get killed all the time, and nothing is done. Not saying that people don't get killed up here in the States, but it's like open season for activists in other countries, because everyone's poor, and when you're poor, you're hungry, and when you're hungry, you misbehave, and that opens the door of killing someone for money. Yeah, there has to be a two-pronged approach to this in order to have a chance. I mean, we're at the edge of not being able to steer the ship around in terms of climate change. And I'll see that later on this year when I'm on St. Paul Island, supporting that tribe with their research.
Thank you for that, Mark. That was, I think, a nice way to sort of wrap this up. I think we're out of time. Laura is coming on because we're at time here.
Okay, Mark Mado, thank you so much. That was a really good session, and I appreciate your thoughts and your wisdom and your time in sharing all this information with us today.